to the time. So I suppose maybe half an hour for each speaker. Is that it was your last? So maybe half an hour for each speaker to present his or her paper. So the two papers to be presented. The first paper is jointly written by Ms. Xu Bijun and Mr. Patrick Leung, and is on the Sino-Japanese War and the collapse of the Qing and Confucian world orders in the face of Japanese imperialism and European acquiescence. So we'll hear this paper presented first, and then we'll move on to the next paper, and I will introduce the topic of next paper later on. So for Ms. Xu and Dr. Leung, who will be speaking first? So maybe the two of you collectively will take about half an hour, yeah, or maybe 40 minutes. Yeah. Okay, thank you.
Thank you, Professor Chen, and good afternoon, everyone. This is my second presentation, which might be seen as a continuation of the one that I just given to you before lunchtime. In our last presentation, we have investigated how Japan sees Ryukyu as a result. And after the seizure in 1870s, the Japanese were trying to enhance their control over another East Asian state, Korea. And I will share our findings with my partner, Bijun. So the Sino-Japanese War was fought from the 1904 to 1905. It's about the independence and the conflicts between Chinese and Japanese control over Korea. It was regarded as a civilized war by some Japanese scholars because they thought the Chinese government was not civilized and the Japanese, they thought themselves as civilized. And as a result of the war, the so-called uncivilized Confucian world order was then replaced by the modern Western international legal order. So, but one question that we would like to pose is that whether the Confucian world order was worse than the international legal order. Actually, the two systems were based on the different historical context between the East and the West. So, but as a result of the war, the old order was replaced. And the second thing we would like to see is whether the war is a just war. To say whether it is a just war, we have to consider two different points. The first one is the aim of the war, which will be reported by my partner Bijun, and then about the process of the war, I will share my personal findings. And lastly, we will review the question why both Confucian world order and the international legal order failed to maintain peace or to stop the war or to stop the Japanese aggression. So I will give the time to Bijun to express our findings about the Japanese aim of the war.
Thank you, Patrick. I'm going to talk about Japan's hidden agenda and its pretext for the first Sino-Japanese War first. Let's begin from the two war declarations from both China and Japan. I quote part of the war declarations here. You can see quite clearly from these declarations. It is firstly issued by Japan towards China, which I quote, under the guidance of Japan, Korea was introduced into the family of nations and became an independent state. However, China's action was a direct injury to Korea and also a menace to the peace of East Asia, etc. And then China issued a counter proclamation of war, which also mentioned the status of Korea, and also said that Japan violated the treaties and not observed international laws. So it can be seen quite clearly from the declarations that the conflict over Korea between China and Japan is the direct cause of this war. So this part is going to see whether it is true that Japan waged this war towards China for the protect of the independence of Korea. And this part argues that Japan was adopting the Western way to colonize Korea by using international law justifying their aggression, and protecting the independence of Korea was only a pretext for Japan to have war with China. And Japan's hidden agenda was to establish its predominance in Asia. Before I go through the incidents before war, I want to offer some background information here. Actually, in the 18th and early 19th century, both Japan and China were confronted with the Western imperialism. So they were in the same situation, and they both suffered from Western imperialism and were forced to sign unequal treaties with Western powers. Then Japan determined to impute Western civilization. Western civilization here includes not only culture, education, and international law, but also means Japan learned to follow the imperialist ways. And in the mind of the Japanese leadership, international law was one of the most important institutions in European international society. So Japan made full use of international law to serve for their diplomacy. And then I am going to look through some incidents happened before war related to Korea to see how Japan realized their final goal step by step. I'm going to look at mainly four incidents here. The first time China and Japan had a great debate over the status of Korea happened in 1875. This debate was triggered by an incident, which is a small Japanese warship was dispatched to survey coastal waters without Korean permission and was shot by the Korean garrison, which triggered the conflict between Korea and Japan. At that time, Japan did not have much influence over Korea, and Japan knew that China, as the sovereign state, had much influence over this area. So Japan at that time sent people to China to seek China's help in opening up Korea to settle down this dispute. However, Japan's proposal was refused by Zhongli Yamen and Li Hongzhang on the basis that even though China and Korea had the tributary relationship, but we never interfere with their own internal affairs. Finding that it was impossible to cooperate with China in opening up Korea, Japan started to deny the relationship, the tributary relationship between China and Korea. I just listed the legal argument used by Japan to support their actions. We can see that when Japan tried to deny the relationship between China and Korea, the argument was that Korea was an independent country and the tributary system was inconsistent with international law. However, the interesting point here is that when Japan tried to apply international law to argue for their actions, Li Hongzhang said that, okay, if you want to talk about international law, then let's see whether your actions are in accordance with international law or violating it. Then Li Hongzhang said that when you sent troops to, when you sent your warship to the Korean coastal water without their permission, it's obvious that you are violating international law. However, this time, Japan responded by saying that Korea had no right to be protected by international law because she never concluded any treaties with other nations. So you can see the inconsistencies here between or among the Japan's legal argument supporting their actions. And then, even though Japan failed to seek China's help in opening up Korea, Japan didn't give up. Only 1 year later, in 1876, Japan employed gunboat diplomacy in opening up Korea and pressed Korea to sign the treaty, which was quite similar to how America treated Japan just several years ago. So you can see Japan just adopted the same way how Western powers treated them to Korea. And we can see from the treaty terms that this treaty signed between Korea and Japan was a typical equal one. Article 4 and Article 5 opened several ports for residence and trades by Japanese subjects, and Article 7 gave the right to Japan freely survey the Korean coast, and Article 10 gave the right of extraterritoriality. And in 1880s, another incident happened. We can see that Japan went a step further in controlling and having more influence on Korea. And in 1884, Japan supported the Capson coup, aiming to reform and modernize Korea. As a sovereign state, China, in request from Korea, sent 1,500 soldiers suppressing it. However, this incident concludes the Convention of Tianjin between China and Japan, which will be discussed by my colleague, Dr. Patrick Liang. However, now I just want to quote one article from this treaty to show you how Japan succeeded in having more control over this area. Article 3 of this treaty stated that in case of any disturbances of a grave nature occurring in Korea, which necessitate the respective countries or either of them to send troops to Korea, it is hereby understood that they shall give each to other previous notice in writing of their intention to do so, and that after the matter is settled, they shall withdraw their troops and not further station them there. How this article should be interpreted and who violated this article will be discussed in part 2. However, this article hence be regarded by many scholars as the one reduced Korea as a co-protectorate under both China and Japan. So it was obviously another diplomatic success for Japan to have more influence on this area. And finally, the Tonghai Rebellion happened in 1894, and then the First Sino-Japanese War happened after that. In 1894, because of the rebellion happened, Korea, as Euro, asked China to send troops putting down this rebellion. So China sent troops there. However, considering that the Convention of Tianjin, which is just the one I mentioned in the last slide, said that neither nation would send troops to Korea without prior notification to the other side. According to that, China informed Japan of their dispatch of troops to Korea. After receiving the notifications from China, Japan replied that they also wanted to send troops there. Let's see Japan's actions here and their legal arguments supporting their actions. When Japan dispatched troops to Korea, they said that this is a right granted by Tianjin Convention. And when China and Korea know that, they feel quite surprised, and they or both requested Japan to withdraw their troops, which was obviously refused by Japan on the grounds that they have the right to protect their legation and consulates in Korea, which was granted by some convention they cite in 1882. But according to the American diplomatic papers, we can see that the truth was that nobody was menacing them. So actually, it was just a pretext. And more interesting thing is that after the rebellion was put down, I mean, the reason for both China and Korea station their troops in Korea did not exist any longer. At this time, China proposed to Japan that, okay, we need to withdraw our troops because they rebellion has been putting down. However, Japan again refused for joint withdrawal of troops after the rebellion has been suppressed. And this time, the reason Japan gave was that the peace was superficial, means we need to help Korea to inform their government in order to help them maintain peace in a long time. And finally, because China and Japan could not conclude any agreement in terms of the Korean affairs, finally Japan occupied the palace of Korea, which was obviously a violation of international law, but however not mentioned in Japanese international scholars' works after war. We can also see Japan's hidden agenda from the terms they asked during the peace negotiation. When China was defeated, Japan, among their internal circles, talk about what terms to ask for. We can see that they asked to annex Liaodong as Japanese territory and also asked to obtain southern Fengtian, which we can see, based on archive research, we can see from their correspondences that the reason why they want this place is because they want to occupy and control Beijing later, and also want to make this place for as a base for land and sea operations, and then finally establish their own predominance in Asia. At the same time, I want to talk a little bit more about the emotions of Japanese ordinary people at this time, and also some influential intellectuals' statements at that time. Actually, the emotions of Japanese people at that period were running really high, and they were actually putting quite a lot of pressure on Japanese government and make Japanese government feel that they can't retreat unless they get some compensations from China or Korea. And some influential intellectuals like Fukuzawa, he also mentioned that Japan's long-term goal is to be the leader in Asia, which you can see here. I quote from his books. And he is the most influential intellectual in Japan, who also had a very big influence on Japanese officials. And Arriga was one of the leading international law scholars during that period of time. And he also regarded war as a tool for states to serve their political purpose. So all this prepared Japan for war with China. So conclusion for this part is that Japan's hidden agenda was to establish the predominance in Asia, and they just followed the Western way to implement an imperialist policy in Asia. And international law for Japan was just a tool to ward off third powers' intervention and win their sympathy as pretext for conquering Korea. And next part will be presented by my colleague Patrick Leung, talking about who violated the international law in terms of the Tianjin Treaty.
So we've just demonstrated that the Japanese aim was not just at all. And the second thing I have to investigate is to see whether the process is also unjust. Is there any body violated the international law or the treaties? First, as Bijun emphasized, the Japanese justification was to protect the Korean independence, and they saw that the tributary system was violating the doctrine of independence. And the second thing is that they said that we just sent troops to Korea to help them to suppress the rebellion. And we were authorized to do so because of the 1885 convention. Despite Korean objection, they told the Korean officials that even if you think it's not necessary to send troops, if we think it is necessary, we won't listen to you. So the convention authorized Japan to do so. So there are three crucial questions to be asked in this session. The first thing is that was there any contradictions between tributary relations and independence? The second thing is that did the 1885 convention justify the Japanese action? And the third one is did Japan really treat Korea as an independent state? First of all, let me introduce you what's the meaning of tributary state. I've just explained what is meant by independent states and dependencies in my last presentation, so I'm not going to waste your time to explain again. But the point here is that did tributary states in the East Asian world mean dependencies in the Western world? That's the problem of translation. It's necessary to find out the exact meaning. In the East Asia, the tributary relations include the rights and the obligations between China and the tributary states. The China had to give investiture to the Korean king, and the Korea had to respect the Chinese superiority, but there is no political intervention inside the relationship. And secondly, China received tributes, and the tributary state, Korea, also received gifts bestowed by China. So some scholars argue that this relationship is somehow exchange of goods. And China would allow Korea to trade in the frontier and in Beijing, while Korea can get the privilege of trading. When we take a careful study in Korea in the 1880s, that's after the arrival of the Western powers. Was there anything changed? Firstly, I have to argue that because there were treaties signed between Korea and the Western powers like Britain and France and United States, the treaties actually demonstrated the Korean independence. And Korea claimed itself as a subordinate state of China while enjoying independence rights. So I think that it's virtually independent because there was no intervention by the Chinese government, and there should be no contradictions between the Chinese style of tributary state with the Western style of independent state. So that was just a problem of translation. You cannot just translate everything in the Chinese culture to English with a similar term. Even if you use a similar term, there should be some minor differences. So the translation actually created ambiguities and pretexts for the Japanese government. Let's move to the second question. Did the convention authorize Japan to send troops to Korea even though Korean government opposed to the expedition? Because the article is very important, so let me read it out. The article mentioned that in case of any disturbance of a grave nature occurring in Korea, which necessitates the respective countries or either of them to send troops to Korea, it is hereby understood that they shall give each to the other previous notice in writing of their intention so to do. So, can we argue that China and Japan received any rights from this convention? Logically speaking, I have to argue that the article just suggested that you can't send troops to Korea without sending notification to China. But it doesn't mean that if you send notifications to China, then you are free to do everything. That's logically speaking, sending notifications to China is just a necessary condition, but not a sufficient condition. And another problem is that was the Korean permission needed in cases of sending troops? It's quite strange that the convention did not mention this condition. But let's look at another draft of the same article. This is an earlier draft, but not adopted as the final version. We can see that the earlier draft said that the Korean king request was necessary for both states to send troops. And quite surprisingly, this article, this draft, was first proposed by Japan, which sent troops finally without Korean permission. This is quite surprising. And it is also surprising that China opposed to this idea. We have to look back to the process of negotiation to see how the two parties perceived this article. I would say that China, represented by Li Hongzhan, was just worried that if there would be a pro-Japanese coup in Korea in the coming future, just like the one happened just in 1882, then the Korean king might be overthrown. And if he is overthrown, he couldn't send requests for Chinese help. So Li Hongzhan did not consent to this version just because he was frightened by the pro-Japanese coup. And but we can see that the Japanese representative Ito Hirobumi implicitly stated that the king's approval was necessary for Japan to send troops, and China only felt that the Korean king could not send requests in some special cases. So the clause was finally changed and it's deleted the wordings about the Korean permission. But we have to see that in the case happened in 1894 in the Tonghak Rebellion, the Korean king was not overthrown. It was not a special case. So in these normal cases, the Korean will should be respected. And the Japanese expedition, despite Korean opposition, can be considered as a violation to the intention of Li Hongzhan and Ito Hirobumi during the negotiation. And if you say that the intention is not important, we have to find other evidence to support this argument. I would say this convention was just an agreement between China and Japan, not Korea. So Koreans should not be bound by this treaty. And the convention in 1885 could not replace the Japan-Korean Treaty in 1876, which recognized Korean independence. So the Korean independence should still be respected by the Japanese government. And in these cases, you are not allowed to send troops to a state, to an independent state without its approval. So I think that the Japanese expedition is not justifiable. And the last question is that was Korean independence respected? This seems to be an easy question because the Japanese just ignored the Korean opposition to the expedition, and they didn't withdraw their troops from Korea after the Tonghak Rebellion was already suppressed. And why they didn't withdraw their troops? Because it's for the preparation for the war, and they also used the forces there to coerce the Korean government into accepting the reforms suggested by the Japanese government. So Japan was actually actively intervened in the Korean internal affairs and using the forces for coercion. So I think that the Japanese did not treat Korea as an independent state as they claimed. And we can move to the next session. This session aims to see why Confucianism and Western international law failed to maintain peace and stop the Japanese aggression in this incident. I have to say that this is very important for the development of Confucianism in the new century, because many contemporary Confucian scholars have suggested reinventing Confucianism by making conversations with some Western values or global values. There should be conversations with Christianity, Muslims, and democracy, human rights, and science. So in this century, while the globalization was happening, we have to see that whether Confucianism is still applicable and to what extent it is useful to maintain the world order. The Confucianism actually aimed at building a harmonious and peaceful world by moral cultivation, as suggested by a presentation yesterday in the Great Learning, the Confucian classics Great Learning. One have to rectify himself to cultivate his moral values, and then to ratify his family, and then his state, and then the whole world by being a moral model for the others. The Confucians believe that when you demonstrate your morality to the others will then follow you. So the next question is whether how the Confucian understood the war. The war was fought as the biggest punitive measure or the biggest criminal punishment. This is something recorded in Guoyu, Chinese classics, and this is quite similar to the international jurisprudence, which might see wars as lawsuits in common law or criminal punishment. But it is quite different from the Western understanding, because according to some international lawyers, you as an independent state can punish the others. But the Confucianism said that the ratification should not be done by war. The best way was to demonstrate your morality. So the Confucius said when distant subjects, you may understand as foreign states, unsubmissive, one should cultivate his moral quality in order to attract them. That means you should not attack them. You should cultivate your morality to attract them to follow you. And even there is a tyrant, you can overthrow him by violent ways, by attacking him. But Confucius regarded such kind of actions as perfectly beautiful, but not perfectly good. And to the Confucianism, they thought that equal states should not launch wars to each other at many normal cases, because only the superior had the right to punish the others. That means if you catch someone steal things from you, you cannot punish him by yourself. You have to send him to the police and to the court and let him punished by the government or the judge. And Confucianism considered the international issue in a similar way. Mencius said that, or Confucius also considered in the same way. They suggested that only the king had the right to punish the feudal lords, while wars among those feudal lords should be unjust. And Mencius had another theory that the heaven-appointed officer has the right. So who is the heaven-appointed officer? This is not a mythical theory. Mencius actually suggested that heaven sees with the eyes of its people, and heaven hears with the ears of its people. So if you send forces to attack another country, and the people of your enemy welcome your forces, then you are just, you are justifiable. But if we, I just briefly introduce some relevant concepts in Confucianism. And here I would like to see whether there are some limitations of Confucianism when we expect it to serve as a peacekeeping philosophy. First of all, the limitation is that Confucianism, if you accord to the pre-teen Confucians, such as Confucius and Mencius, they were relying on the superior to maintain the order. That means Confucianism, they suppose that there was a king to rule the whole world. They didn't imagine a situation like the contemporary world in which there are many equal states. So it's different from the Westphalian system. And in the 19th century, the Chinese tributary system and the Chinese superiority was eventually collapsed by the Western aggression. So, and it's more serious that before the First World War, there was no League of Nations, no ICJ, and no United Nations. So who is the superiority? Who had the right to punish the others? I think this can be considered as the first limitation. And the second limitation is very simple because Confucian emphasized on self-cultivation, and they imagine that, or they consider that the others will follow your morality. But it has been proven wrong by many historical facts that I don't need to give you examples. And the third thing is that the lack of mechanism to help the weak and stop aggression. That means Confucian did not have a very practical mechanism to help the weak with the absence of a superior. There is a story in Mencius. He said that when the Qi, one of the feudal domain in the Zhou dynasty, fortified the frontier, its neighbor state, the Tang, was threatened. In the contemporary world, a potential threat can be seen as a reason for a war. Just like if I see you are developing nuclear weapons, I can send troops to your state to punish you. Some international lawyers may consider the situation like this. But in Confucianism, Mencius said nothing should be done to resist this so-called potential threat. You should just cultivate your morality as usual. If you are virtuous, you can leave your state and your people will then follow you. This is the first option. And the second option is that you are weak and you can choose to stay here and die. You can defend your state with your life, but you will then die. So I think that he just asked the Lord of the Tang to choose between these two options. So I think that the Confucianism was a moral order rather than a practical political order. And in the 19th century, when the Chinese superiority was collapsed by the West, the weaknesses or the lack of mechanism inside Confucianism was eventually exposed. Then I will pass the time to BG.
I'm going to talk about Western response to Japan's aggression and how they finally gave up a mediation to just let Japan occupy Korea. Let's firstly look at Western perception of Japan's action in Korea, which means whether did they think that Japan actually violated international law. I again based my research on archives, and here I just look at some American and British archives to see how they perceive Japan's action just before war. We can see that first one is the telegram sent from the U.S. Navy Force, Asian Station, to the U.S. Navy Force, which said that if it was not deliberately provoking the war with China, it was difficult to know what Japan's aggression on Korea means. And also in another telegram, they also said that Korea independence, sovereignty should be respected, and also they regarded Japan's action as the possibility to wage an unjust war. And in British correspondences, we can see that Britain even predicted Japan's plan, which means the hidden agenda, which I have already proved in the first part. Britain said that U.C. O'Connor to the Kimberley, he attached the political forecast of the design of Japan in regard to Korea, which includes the Japanese will seize the kingdom of Korea, will try to conquer and return Korea, and attack upon the southern port, probably Formosa or Fukto. So you can see that it was pretty clear that Western countries, they regarded Japan's action as violating international law. And Japan's hidden agenda had been known by Western countries. Then let's see how these Western powers react to Japan's aggression. Here I mainly look at 4 countries, like Britain, Russia, US, and Italy. Britain and Russia were the 2 countries whose interests were most deeply related to Asia. Britain, at the very first beginning, Britain tried to bring China and Japan back to negotiation. And she wants to make each other halfway. However, perceiving that the war was unavoidable in the long run, the British government finally gave up the mediation and just request Japan to agree in advance not to take any military action against Shanghai and its line of communications. I'm going to explain how Japan understood each country's position and how they react to each Western powers to see how they finally succeed in making every Western power retreat. And for Russia, Russia was much tougher than Britain. We can see from the wordings from Russia to Japan. She actually exerts its utmost efforts to persuade Japan to withdraw their troops from Korea. And she said that she warned Japan that if she refused to recall her troops, she will be obliged to bear serious responsibility for the consequences. So we can see from the archives that Ito and Musu, the foreign minister of Japan at that time, they bear actually enormous risks in doing the diplomatic affairs dealing with Russia. However, finally, Russia gave up. She changed her mind dramatically. The reason for that is that you can see here, Japan planned to make use of Britain as a counterbalance of Russia. So Japan just told Russia that if you stand beside China, Britain will join us, and also other powers were very likely to see Russia trapped in Asian affairs. So by considering that, and also considering that Russia was not prepared to intervene by force, Russia finally gave up. And in the final telegram Russia sent to Japan, they just said that they won't involve further in this issue. And how about US? Korea actually asked US for intervention. And Britain also approached the United States to see whether she would like to join them to interfere the affairs here and stop Japan's aggression, but U.S. just refused. U.S. just showed her sympathy to Korea, and U.S. said that we just hope that Korea's sovereignty and independence could be respected, but they said that they won't intervene jointly with other powers. And Italy joined just before the war. Japan just simply ignored Italy's proposal, and Japan only issued a counter proposal back to Italy after Japan occupied the balance of Korea. Let's see. I think the success of Japan's diplomacy based on their precise or exact understanding and judgment of Western powers' intentions here. And also based on Japan's understanding of the nature of Western international law, because Japan knows that every country just care about their own interests. For Britain, we can see that Japan said that Britain's main concern was her own political and commercial interest, and they desired to maintain the peace of the Far East. So if we can guarantee Britain that their interests won't be damaged, maybe Britain will turn to be friendly to us. And finally, Japan succeeded. For Russia, we mentioned just now that they use Britain as a counterbalance of Russia. And also Japan believed that Russia won't interfere by force. That's the bottom line, you see. And US, here is the paragraph I quote from Musu's memorial. And he regarded Americans as a friend of him and see that Americans just want to show their desire for peace, and they just want to show that they can't just simply ignore Korea's plea for assistance. So US won't interfere seriously. And Italy, Japan regarded Italian action just to impress her position in the Far East upon the other countries. Therefore, it was not her concern whether the plan would succeed or not. So we can see that it is unfortunate that finally all the countries chose to retreat from this dispute, or simply just pretend to play some role in stopping the aggression happening, even though they knew that Japan's aggression was in violation of international law. And also international law in these circumstances was useless in preventing aggression happening, and even worse, international law was adopted by the stronger powers to justifying their actions. And finally, we're going to draw our conclusion for the whole presentation. And the Japanese scholars always argue this war as the conflict between the civilized states, Japan, and the uncivilized states, China, in order to maintain stability and peace in the Far East. However, this article tries to argue that, firstly, Japan was not constructing a peaceful East Asian world, but trying to establish its own predominance in Asia by replacing the Chinese superiority and hegemony by using international law as pretext. And secondly, facing the Japanese aggression, both Confucian and international legal world order could not offer a solution to the crisis. And finally, maybe a more reasonable world order which could efficiently prevent aggression and expansionism had yet to be constructed. Thank you.
Thank you very much to both speakers. So before we discuss this paper, we'll move to hear the second paper of this session. Professor Yi Ping from the University of Beijing, Peking, is going to talk about the late 19th century Martin-led debate on whether Western-style international law existed in ancient China and could be revived, and its implications for continuing Chinese debate on whether there is a need for a distinctive Chinese approach to international order. So may I invite Professor Yi to present.
Thank you, Professor. Thank you, Professor Chen. My presentation is about an American missionary, Martin, and his Chinese followers. As regard Martin, we have had intensive discussion yesterday. The story I would like to share with you, however, is a little different, which is about an interesting proposition put forward by Martin and his Chinese followers. They argued that the international law, though has been regarded as an creation of Europe in the 17th century actually had already existed in ancient China. This proposition was quite different from the Western mainstream understanding. I will describe this proposition and analyze the logic of it in detail. My presentation is composed of 4 parts. After the introduction, I will begin with the translation and the introductory work of Martin, who was the precursor of the advocates of ancient China international law. Then I will move on to a chronological analysis of the relevant propositions by Chinese intellectuals in the early 20th century. This period can be further divided into 3 stages: embryonic, developing, and maturation. Finally, I will conclude the propositions mentioned above. It's well known that modern international law originated in Europe. It was not until the European states aggressively expanded their colonies from the 16th century that non-European countries became widely exposed to the European international law. As a result, around the late 19th century, with non-European countries' eventual acceptance of European international law, the latter became a universally applicable global system. The 19th century then became the time of widening of European international law. This widening process, however, faced countless obstacles. Non-European countries, especially China, demonstrated very complex attitude toward the Western legal system. Chinese intellectuals, when understanding and interpreting unfamiliar European concepts, always used the traditional Confucian concept to selectively adopt portions of the European thinking. In the end, the Chinese conventional legal thinking was embedded in the understanding of European international law. Among Chinese intellectuals' response to the Western legal system, the most interesting argument was on the ancient China international law. Considerable intellectuals examined and demonstrated that international law had already existed in China during the spring and autumn and warring states periods, that is from 770 BC to 221 BC. They argued that the ancient China international law was not only highly similar to, but also superior to, the contemporary European international law. Then I will talk about how these Chinese intellectuals describe and analyze the ancient China international law. Interestingly, the first person to systematically demonstrate the relation between ancient China and modern international law was not a Chinese person, but an American missionary, Martin. Martin lived in China for over half a century. During his stay in China, he took charge of translating and publishing Chinese versions of Western international legal writings. At the same time, he devoted himself to introducing ancient China international law to Westerners. These 2 tasks were interrelated and had a deep impact on Chinese intellectuals' recognition and understanding of international law. Among the translation of Martin, the first and the most influential one was the classic textbook, Elements of International Law, written by American diplomat Hui Tong. The Chinese version of this book, with the title of 万国公法, enjoyed a highly authoritative status and widespread dissemination, and was a popular reading material among Chinese intellectuals at that time. When Martin started to translate this book, however, what he did exceeded a simple translation. Why he's doing so? Partly because At that time, many English vocabulary words didn't have corresponding Chinese expressions. To achieve mutual understanding, Martin had no choice but to creatively establish hypothetical relations between these two languages. But a more important reason is that Martin had his own aspiration and inclinations that made him beyond mere translator. For example, the translation of 万国公法, this word, was a very delicate one. In the vocabulary of Western international law at the time, both international law and law of nations referred to this legal system. These two words were sometimes misused. Strictly speaking, however, they represented two different tendencies. Following the tradition of jus gentium, the expression of law of nations suggested a meaning of universality and justice, with an emphasis on natural law basis. The expression of international law, however, focused on a positive law perspective, emphasizing the will of sovereignty and the importance of state practice. To elaborate the difference between these two words, Huitong introduced German jurist Hefter's legal theory in his book. According to Hefter, jus gentium, or its English word, law of nations, is a law common to all mankind and which no people can refuse to acknowledge, and the protection of which may be claimed by all men and by all states. While the other term, international law, as a law between states, cannot sufficiently express this idea of jus gentium. Therefore, Hefter didn't admit the term international law. Huitong, however, couldn't agree with Hefter's view in this regard. He quoted some most famous jurists like Grotius, Binckschuk, Leibniz, and Montesquieu in order to demonstrate there is no uniform law of nations. Huitong further referred to Dr. Zouch, French Chancellor, Daxor, and Mr. Benson to show that the terms international law and droit international have now taken root in the English and the French languages and are constantly used in all discussions connected with the science, and we cannot agree with Hefter in prescribing them. With regard to Huitong's critical opinion against Hefter and Huitong's obvious preference to the term international law, Martin didn't translate this section at all. Furthermore, though Huitong deliberately distinguished between international law and the law of nations in his book, Martin ignored the distinction and translated the two words uniformly as 万国公法 or simply 公法, which sounds closer to jus gentium. By means of it, Martin strengthened the international legal system's natural law character and demonstrated its universal validity. Actually, in the translator's preface of 万国公法, Martin clearly expressed his intention of guiding Chinese people into a moral, righteous, and universal understanding on international law. He stated, to its fundamental principles, the Chinese mind is prepared to yield ready assent in their state ritual as well as their canonical books. They acknowledge a supreme arbiter of human destiny, to whom kings and princes are responsible for their exercise of delegated power. And in theory, no people are more ready to admit that his law is inscribed on the human heart. The relations of nations considered as moral persons and their reciprocal obligations as deduced from this maxim they are thoroughly able to comprehend. As a missionary, Martin reconciled several perspectives, including natural law, Christianity, and morality. By virtue of them, international legal system seems to inherently possess moral, righteous, and universal character. On the other hand, Martin, by making full use of the diverse implications of Gong in Chinese culture, further strengthened the universal, impartial, and legitimate character of this legal system. In the explanatory note of the Chinese version, Martin pointed out that rules contained in this book, which were named 万国公法, are implemented and respected by all nations rather than one. The expression of Gong in the translation encompassed a wide territorial scope and combined with the meaning of openness and generality, which was further strengthened by the expression of 万国, all nations. Then he added that the so-called 公师 publicists in this book are scholars or ministers of states who discuss and analyze the relations between states. They are called 公师 because they analyze impartially rather than for the interest of their own states. The expression of Gong here means impartiality without prejudice. And then, in the first chapter, when Martin clarified the sources of international law, he further stated, if there is no legislative authority which determines 公法, from what authority is 公法 derived? The origin of this law must be sought in the principles of justice applicable to all relations. The meaning of Gong here expressed ethical implications of fairness, justice, and equality. The expression of Gong in Martin's translation reminded Chinese intellectuals of traditional philosophical concepts. Given the yearning for the kingly way political order, Chinese people had a strong affinity for an ideal international order governed by this 公法, and were accustomed to considering the meaning of such affairs through moral judgment. Therefore, Chinese people could accept this Western legal system as a cultural idea possessing universal significance. This was exactly what Martin desired. Only this way could European international law be separated from its original specific historical background and integrated into another culture, thus becoming the true international law. Apart from translation activities, Martin also devoted himself to introduce China to the West. At the International Congress of Orientals in Berlin in 1881, he presented a paper, International Law in Ancient China. Later, this paper was translated into Chinese under the title of 中国古世公法论略. Martin's article aimed to prove that international law already existed in the spring and autumn and warring states periods of China. In his opinion, international law had two prerequisites: the presence of multiple equal states and necessity for interaction among them. Those two prerequisites were satisfied in ancient China. By analyzing classic literature of the time, such as 周礼, 春秋三传, 战国策, and so on, Martin concluded that in the form of rights, the interacting rules among states in the spring and autumn and warring states periods were equivalent to the rules of European international law. This review showed that even without the name of international law. The elements of international law had existed in China since ancient times, and thus Chinese people had a tradition of abiding by international law. Martin's purpose in doing so was obvious. For one thing, his task as a missionary was to disseminate Western religious and legal ideas in China, a task that he well knew could only be accomplished by reframing them in accordance with Chinese traditional ideas. Since Chinese were familiar with their own traditions, including such rules, they ought to be willing to accept them. For another, many Westerners then had expressed doubt about the application of international law outside Europe, under the notion that the East was inferior to the West. Some Western international legal scholars held that international law, as a product of European civilization, was by nature inapplicable outside Europe, or only partially or unequally applicable. Faced with this backdrop, Martin endeavored to prove to the West that, given the elements of international law in the spring and autumn and warring states periods, China could and should become a member of the family of nations. In a sense, Martin's commitment to dissemination of ancient China international law was consistent with his translation work. Both efforts worked to expand the applicable scope of international law. To achieve this aim, he had to create or construct a common ideological basis in order to render international law a true universal regulatory system, applicable for all states, irrespective of the East or the West, the past or the present. In fact, his efforts were not in vain. Nearly 20 years after his speech in Berlin, the proposition that international law existed in ancient China elicited close attention and active response from Chinese intellectuals. In the late 19th century, China, with a long tradition of the Huayi distinction and a view of itself as superior to the rest of the world, suddenly faced the Western powers' gunboat policy and found itself as an ordinary, or even worse, inferior member of the global community. This unexpected change, in turn, had a strong impact on Chinese perception of the international order. The coexistence of numerous states reminded Chinese intellectuals of the spring and autumn and warring states periods. Considerable scholars pointed out the huge similarity between the society of ancient China and the modern international community of the West in order to find solutions to China's imminent crisis at the time. From the turning point of the centuries until the outbreak of the Second World War, there appeared a large number of literatures in this regard. The period can be further divided into 3 stages: embryonic, developing, and maturation. The first stage refers to the first 10 years of the 20th century, during which some Chinese students studying abroad engaged in comparisons between Chinese classics and Western literature. For example, in 1903, a Chinese student with the English name of Chang Yuchuan submitted his master's thesis to the Yale University Law School, entitled China's Position in International Law. To the best of my knowledge, this thesis was the first English language international law thesis written by Chinese person. Following the source Martin put forward in 1881, his thesis compared some Chinese classics with the works of Hugo Grotius and concluded that a large number of international legal regulations had already existed in the Zhou dynasty, that is from 1046 BC to 256 BC. According to Chang Yuchuan, those regulations were concerned with the independence and equality of states, territory, jurisdiction, diplomatic agent system, and law of war and neutrality, and so on. 4 years later, another Chinese student, Ma Derun, acquired a doctoral degree of law in Germany. In his doctoral thesis submitted to the Berlin University in 1907, Ma Derun focused on China's international status, in particular pointing out that there already existed many independent states in China's spring and autumn and warring states period. In the author's opinion, if China had acted like Europe, where the presence of dense independent states became a common situation since the disintegration of the Roman Empire, China undeniably also would have had international interactions and international law. It's worth noting that Chang Yuchuan and Ma Derun utilized the Western language, quoted Western literature skillfully, and without hesitation adopted Western standards to assess present China. Perhaps Western perceptions in their subconsciousness were a universally applicable knowledge. This point were exactly what Martin strongly called for and desired 20 years earlier, making Western international law a universally applicable system. Chinese students studying abroad at the beginning of the 20th century responded to Martin's prognosis. Though their arguments and demonstrations lacked careful deliberation, they brought the issue of ancient China international law to the center stage and make it attracted more academic attention in the next period. The next period, that is developing stage, which refers to the period from 1910 to 1930, is significant for the gradually maturing process of international legal research in China. A number of professional jurists and historians emerged during this period. In some ways, the viewpoint of these scholars followed the thinking developed by Martin and early Chinese students studying abroad. Many of them, for example, mentioned the translation and the introductory work of Martin in their monographs or textbooks and spoke highly of it. Some of them even quoted Martin's article, 中国古世公法论略, in its entirety. They and Martin were in a consensus on one particular issue, which is that in ancient China, ideas and practices relating to international law already existed. Furthermore, they were vehemently opposed to the views expressed by some Westerners who despised China and objected to the application of international law outside Europe. Of course, the succession of Martin is only part of this story. New changes and developments emerged during this period, primarily in the following two respects. First, some scholars began criticizing Martin's theories. They sought additional historical materials and performed more precise studies to uncover a greater significance and value of ancient China international law. For example, in Zhang Xingcheng's opinion, Martin's research on ancient China international law was merely a brief sketch of a few examples rather than a thorough examination. And moreover, Martin's arguments, such as his understanding of the feudal lord's ranking system, contained errors. In mentioning this mistake, Zhang Xingcheng pointed out that while small mistakes like this do no harm to its main idea, they suffice to show that however clearly foreigners are able to understand us, it is us, the Chinese people, who can best express ourselves and the true reality of our history with complete accuracy. Chinese scholars at the time thus had deliberately moved from passively absorbing Western knowledge towards consciously developing indigenous research. Besides the criticism towards Martin, many scholars in this period who were well versed in both Western and Chinese cultural studies also tended to compare these two traditions. Some scholars like to compare the Confucian tradition with the Greek and the Roman cultures, argued that both traditions were substantively the same. For instance, He Bingsong, a very famous historian, claimed that just like Greeks and Romans, ancient China states were heavily theocratic. Our ancestors believed that fidelity is the governing rule for all international treaties. How is this any different from ancient Romans holding fides as the source of all diplomatic relations? Some scholars made bolder claims that the concept of international law had a longer history in China than in the West. Ning Xiewan, a prominent jurist then, pointed out that the independence and equality of states are the two prerequisites for the birth of international law. The spring and autumn period already fulfilled these requirements, while the ancient Greeks, who treated foreigners and barbarians and captives as slaves, and the ancient Romans, who aimed to conquer the whole world and build the one and only empire, didn't tolerate the existence of other independent and equal states. Their practices were contradictory to the fundamental principles of international law and could not possibly have given birth to the modern international law as we know it. Therefore, the international relationships and the ideas of international law originated earlier in the East than in the West. Furthermore, in Zhang Xingcheng's opinion, compared to modern Western legal system, international law in the spring and autumn period not only appeared earlier, but also was more thoughtful and had loftier ideals. In ancient China, the primary criteria to be a member of the international community were related only to the level of civilization, rather than races or religions. Therefore, compared to the views expressed by some Western scholars that international law was applicable only to Christian nations, international law in the spring and autumn period was closer to achieving the goal of a utopian social order. Besides comparing concepts, scholars were more interested in finding abundant historical materials to prove that a large number of rules, institutions, systems, and state practices, which were similar to those of Western international law, have already existed in ancient China. He Bingsong, for example, claimed that rights could be considered the same as customs in modern Western international law. To prove his point, he cited a large number of historical materials concerning diplomatic delegations, treaties, alliances, international interventions, and so on. Another scholar, Tan Zhuohong, said that in the spring and autumn and warring states periods, feudal lords governed their own states separately, while all of them keep loyalty to the emperor of Zhou. Similarly, in medieval Europe, all European states were self-governed, while they were under the command of the Pope. Therefore, an international community had already formed in ancient China. Ning Xiewan listed practices in international law during the ancient time, such as alliances, peaceful negotiations, disaster aid among the states, trade, international trade, and the treaty conclusions, and so on. Based on this observation, he stated that if there had been scholars in ancient China who, like Grotius of the West, categorized different types of general practices of international law at that time and wrote them down, Eastern international law might well have been the cradle of global civilization. From foregoing analysis, we can find that research on ancient China international law demonstrated obvious progress during the developing stage. Unlike early Chinese students studying abroad, who took for granted that Western standards could be used to measure China's situation, and the Chinese materials could only be used to prove the validity of Western theories. It was clear that scholars in this period intended to treat Western international law only as a reference, not a standard. Such new characteristics laid a solid foundation for further study in the next maturation stage. The maturation stage refers to the approximately 10-year period from 1930 to the eve of Second World War. Up to this point, it had been almost 100 years since the intellectuals of the late Qing dynasty had first become exposed in the substantive way to the Western legal system. The conflict and the integration of Eastern and Western cultures, which had experienced nearly 100 years accumulation, had reached a considerable scale and depth. At that time, the Chinese intellectuals' research into ancient international law, China international law, also reached its highest level. Indeed, most intellectuals still followed earlier approaches on certain basic questions. For instance, the motivation of their research was still to respond to some Western scholars' criticism to China and defend for themselves. In order to make their opinion more persuasive, they continued to refer to Martin's thesis in favor of this view. The purpose of this reference, however, was to not only provide proof, but also point out the problem in prior research and reflect on it. This reflection contributed to forming a good tradition of academic thinking and, in fact, did push the research in this field to a relatively mature stage. First, intellectuals at this stage were no longer satisfied with approaches that focused only on a few specific issues, and instead were dedicated to establishing a comprehensive structure so as to systematically analyze the complex interaction among ancient China states. Xu Chuanbao, Doctor of Law at the University of Paris, published a Chinese book about the international law in the pre-Qing, Xianqing period in 1931. The structure of his book differed significantly from the Western prevalent textbooks of international law at that time. Xu's book consisted of two main parts: diplomatic institutions and international relations. The latter was further divided into three major domains: public international law, international criminal law, and private international law, among which public international law was the obvious emphasis, occupying more than half of the whole book. In public international law, the international relations were divided into four categories: 和谐关系, harmonious relationship; 不睦关系, unfriendly relationship; 战争关系, warring relationship; and 会同关系, conferential relationship. Taking the harmonious relationship as an example, the writer unfolded his analysis in detail from four perspectives, including political relationships, economic relationships, legal relationships, and compassionate relationships. The political relationship further comprehended the formal political relationship and substantive political relationship. The formal political relationship included 聘问, that is, exchange of invoice between states, and the 交劳, that is, the receiving and welcoming in the border regions, and the 谢守, that is, the foreign monarch reviewing troops at home. Even further, 聘问 embraced 聘问 in normal times and 聘问 at the time of a new monarch, enthronement. The latter having three further different layers beneath it. At the lowest layer, the writer illustrated every term with examples, which will not be elaborated here. It can be said that the system of this book were newly created by the writer on the basis of a comprehensive examination of international practice in ancient China. The writer built a structure in the utmost accordance with the nature of these subjects and followed the terms in ancient classics, rather than unthinkingly adopting those used in the Western international law. Such new approach was not rare among writings during this period. Chen Guyuan and other scholars also put forward their own legal frameworks. As the time limit, other approaches will not be elaborated here. In a word, such self-created systems had reached a relatively high level of systemization, revealing Chinese scholars' original thinking and their distinctive perception of international law and society. They neither entrenched themselves in their own traditions nor blindly followed Western tendencies, but rather devoted themselves to establishing a new system above the two systems. Today, we tend to think of the universalization of international law as the global expansion of European international law. The European international law, however, in the process of expansion, failed to directly replace the conventional legal culture of non-European areas. A true universalism cannot come from unilateral expansion. Rather, it must derive from genuine intellectual interaction between Europe and non-European states. Apart from structural innovations, scholars of this period also made many interesting observations on the content of ancient China international law. In the Western literature of international law around the late 19th or early 20th century, it's uncommon to bracket both naturalism and positivism as sources of law. In other words, it was infrequent to integrate natural law and international morality and customs and treaties together. In spite of this Western mainstream tendency, Chinese scholars of that era almost simultaneously applied a dual perspective approach, which combined naturalism with positivism when discussing the sources of ancient China international law. This dual perspective approach was not merely an unconscious mixture or simple reconciliation of the two methodologies, but rather a deliberate and purposeful approach. For example, as regards the ritual system of the Zhou dynasty and the relationship between the Emperor of Zhou and the feudal lords, Chen Guyuan explained his view as follows. At first glance, it seems unreasonable that ancient China international law was applied according to the supreme degree, as the existing international law was based on the principle of equality of nations, which means that no state was superior to others. In my humble opinion, however, such international law is not true international law. I prefer to call it diplomatic law. Only when there is a superstate organization, such as a World Republic or Federation of Nations, which oversees the application of international law, can international law be truly effective. The Emperor of Zhou was above those feudal lords, but they each were a component of the Zhou Empire and obeyed the ritual system enacted by the Emperor of Zhou. Moreover, though the Emperor was the supreme authority, he didn't infringe upon the lords, except that he would launch an imperial conquest if an infringement or invasion occurred between lords. Under this system, international law functioned well and international peace was maintained. In Chen Guyuan's opinion, ancient China international law was superior to Western international law. The universal and prevalent authority of the Emperor of Zhou exerted certain binding force on the behavior of states, and thus contributed to the maintenance of interstate peace and the strengthening of international law. It's this law that could be called true international law. In other words, international law adequately functioned only when there existed a superior entity, which is above various independent and equal states. To some extent, such superior and universal order embodied in the man-made ritual system was not unlike natural law. The international law above states and the international law between states were not incompatible in ancient China. The former guaranteed the effective operation of the latter. That is precisely why the dual perspective approach was widely accepted by Chinese scholars at the time. Based upon such understanding, Chen Guyuan further classified ancient China international law into 4 categories. The first, Li, international rules. The second, Xing, international morals. Third, Jing, international committee. And the last one, Yi, international axioms. According to his summary, international morals promote the observance of international rules, while international committee facilitates the practice of international rules. International morals, international committee, and the international rules supplement each other and together help preserve international axioms. This is the comprehensive outlook of international relations in ancient times. In a sense, such interpretation is the most incisive summary of ancient China international law by a Chinese intellectual. Recalling Martin's translation activities in the late 19th century, one will discover that his recognition of the universal order and the natural law basis underlying positive international law were, to some extent, continued by Chinese scholar works. This recognition shared by Martin and the Chinese scholars, however, was contrary to the mainstream view in the West and the international practice at the time. On a theoretical level, since the 19th century, the positivist view gradually dominated the natural law perspective, as exemplified by the rising popularity of the term international law in preferences to the law of nations. On the practical level, the main theme of the international order at the time was colonization and the so-called jungle law. Even inside China, traditional sorts of universalism were declining. Strangely enough, however, contrary to the mainstream understanding, the early 20th century saw a group of scholars who argued for the existence of international law in ancient China, which they believed to be consistent with, or even more reasonable than the contemporary Western legal system. Interestingly, these scholars, most of whom had studied abroad and were supposedly the most westernized group, resisted westernization and strongly supported the superiority of the Chinese traditional culture. When they touched upon the evolution of special rules and regulations through state practice, their real concern was the underlying value of the maintenance of a universal order. From an academic point of view, the arguments made by Martin and his Chinese followers were highly debatable. However, it was not its legal correctness, but the perspective reflected therein that matters. The difference between Martin and the early 20th century Chinese scholars was that while Martin's efforts aimed to introduce Western international law into China, his Chinese scholars hoped, through recalling and excavating the traces of ancient China international law, to express a gesture of resistance towards the Western cultural invasion and to affirm, publicize, and even resurrect the Chinese traditional culture. While they were in favor of or even cite Martin's views and arguments, their intention differed from Martin's. Confronted Confronted by Western colonizers armed with weapons and laws, often using the latter to justify the former, arguing for the existence of ancient China international law was perhaps a reasonable way to protest the Westerners' heavy-handed logic. They used the international law as a symbol of civilization, not only to prove to the West that China should and could be a member of the international community, but also to carry forward ancient China international law as a way to maintain Chinese rich cultural tradition in a global order governed by the West, and to create a truly universal discourse based on their own tradition as well as the current context. They were looking forward to the day when Chinese civilization would once again help illuminate the world. Such efforts may have been difficult or even futile in the face of the harsh reality, and most of their efforts have been forgotten. However, it was their destiny to fight such an unbeatable foe. When their works are revisited today, they still touch a chord somewhere in the hearts of the readers. For they might be the swan song of the Chinese intellectuals who rose up against the oppression of imperialism and sought a more balanced world order. This is the end of my presentation. Thank you.
Thank you very much, Professor Yi. I think we should still have about 20 minutes for discussion before we have the break. So may I collect a few questions and comments from the floor before I would invite the speakers to respond. Yes, Dr. Smith.
If I may be so immodest to ask a question to all of the presenters of the papers, to explain about the Chinese significance of the difference between emperors on the one hand and kings on the other. To explain the background of my question, I think the difference between emperor and kings played a quite enormous role in the development of sovereignty in Europe. So first of all, there had been one emperor and a number of kings. Then the French kings were favored under canon law, declared Rex est Imperator in regno suo, so emperor in his own realm. Then later, I think in English texts in the 17th and 18th century, the king is not referred to as by his royal majesty, but by his imperial majesty. So over time, in Europe, the concept of the emperor eroded and a kind of sovereignty amongst the rulers developed. If I'm not completely mistaken, in Korea, the king was referred to as king, I think, until 1897, and after the tribute to China had been abolished or abandoned, he called himself emperor. Is there a kind of legal significance attached to that retitling of the monarch?
Maybe we'll first invite Dr. Leung to talk about the Korean king and the Chinese emperor. And then after then, maybe I don't know whether Professor Yi would like to talk about the kings of the 春秋战国时代.
Okay, thank you for your question. So let me introduce the difference between the Korean king and the Korean emperor to you. Actually, there was the Chinese belief that there should only be one emperor in the world, while the Korean government had to receive Chinese investiture, so they could not call their ruler as the emperor. Instead, they call them their rulers were called as a king. But after the let me see. After the first Sino-Japanese War and the Korean government was forced to terminate its relationship with the Chinese government, and so but they were supported by Russia instead of China. And with the help of Russia, they proclaimed their king as the emperor. So I think that the meaning or the difference between a king and an emperor in the East Asian world is not the same as the meaning or the difference in the West. But the difference in the name of the Korean rulers actually show that Korean became completely independent and became unrelated to the Chinese Empire.
May I perhaps ask a question in addition without wanting to intervene too much, but if I understand correctly, also the ruler of Vietnam or of Annam referred to himself as emperor, and also the Japanese ruler.
Thank you. Yes, it's the same in Vietnam and in Ryukyu, just the state that I just presented in my before the lunch. And yes, it's right to many other tributary states, but Japan was different because Japan did not receive investiture from China. So their ruler was called the Tenor, that means the emperor and from the heaven, or is also called Mikado in Japanese language. So it's only different in Japan because it did not receive investiture.
Before Professor Yi, would you like to speak now? Speak.
Yeah, I'll just help my friend, Professor Yiping, out. And she just explained to me about that question regarding the relation between emperor and king. In Europe, only by breaking the authority of the emperor that international law came to existence. But in China, the concept of law, international law was different. Only by having the emperor above the kings could we have a law above the little kingdoms. So that's the difference. That's the understanding of the scholars that Professor Yiping has discussed before, their understanding of law in China.
I think this is in the context of the spring and autumn and warring state periods, when there was a Zhou, son of heaven, as Professor Wang talked about this morning, and then the feudal lords became kings of various pieces of territories called kingdoms.
Yeah, it's following up on this discussion. Yeah, thanks to all of you for very rich papers. But I'm trying to understand, I think, the concept of tributary state and law in first paper, but also in relation to your comments just now. So am I to understand the tributary state as existing in a system of what you just called the Chinese equivalent of international law? And then if I understand your remarks earlier, you were arguing that the tributary state is compatible with the idea of independence. But on that same sheet, there was also the word superiority. So that you didn't really relate to in the transference to the independence in the so-called Western law framework. And in the Western international law framework or international law system, you could say that independence comes with equality, not with superiority. So I'm struggling there for understanding, and maybe you can help me out. There is another point related to this, a second question to both of you, first paper, and that has to do with, again, a bit use of terms. One has to be cautious, of course, with the use of all kinds of labels. Okay. So if I understand your argument correctly, in the beginning you're starting out by saying that you engage with Western international law. In the end, you come to the conclusion that Japanese application of international law was in fact a pretext, which, I mean, I'm fully with your final conclusion. International law is used often as a pretext, whether it's in the East or the West. I mean, realists have written all kinds of books about it. So ultimately, I understand fully your conclusion that international law is used, in this case, Japanese, in the way they apply it. But you also indicate that a number of Western powers didn't agree with this application or kind of moved away from it. And then it goes back to your first remark where you say, where you relate it really as the application of the Western international law. And there I think one should be a bit cautious. Also not to undermine your own argument, not to be wondering how you see.
Thank you. For the first question about okay. For the first question, the meaning of the tributary state, I must admit that it would be ambiguous if we try to understand this term in international law. You can't just say it is completely an independent state. But on the other hand, you can't say it's completely a dependency. So I would argue that it is virtually independent. That means it's at least the Chinese superiority nominally. But if we consider the real meaning or the exact meaning of the dependencies in Western international law, I would say there should be something like the sovereignty is not complete, and they cannot sign treaties with other sovereignty states, and maybe they cannot declare wars, but the Korean government could sign contracts with, sign treaties with United States and the France and the British government. And so I think it is important to pay attention to the Korean note sent to the Western states, mentioning that it is Chinese subordinate state with independence rights. That's what the Koreans trying to explain to the West. And so I would, to conclude, I would just say it's virtually independent, but you cannot just say it's completely independent or completely dependency. Yes, thank you.
Between the tributary system and the Western international system. What Patrick just said, the superiority is, within the Chinese tributary system is more like a nominal one, which means that China always wants the other countries to show respect to her, which always can be seen in culture, in something like this. For example, China will wanted to see other countries to send tributes to them. However, they didn't aim to benefit from them. From the perspective of economics, and sometimes they will send more things back to those tributary countries, and that's why those countries always benefit more than China by sending tribute to China. So China, under these circumstances, care more about their nominal thing, and also for the independent. I think the reason why China always call Korea and the other tributary states independent is because they want to show that they won't just interfere with their internal affairs, with their own purpose. They will just interfere every time when those tributary states request them to do so. And Chinese always put the tributary system into the family thing. They always regarded those tributary states as their son or children, and they themselves regarded themselves as the father, something like that. So in Chinese culture, independence does not necessarily exist only in the equal circumstances. Like within the family, when the sons grow up, they're older than 18 years old, they become independent. But that does not necessarily mean that they should not show respect to their parents. So I think that's the logic of the Chinese culture, why they, on the one hand, call these countries independent, on the other, they think that they need to show some responsibility in helping these countries to face some difficulties like that.
Yes, Professor Kim?
Actually, that was what I was going to say. In a sense, I'm commenting your presentation, also I'm answering Anne's question, because tributary system was actually invented by basically Zhou people, actually. When Zhou people actually, you guys rightly noted they were clan, right? This particular clan seized the power of Shang dynasty, and then they came up with this whole narrative that, well, these were tyrants and we are the righteous, virtuous people, and then we created this new dynasty, and we got this mandate of heaven. When they created this new dynasty, actually, since this is a small clan, actually, not small, but this is a clan, so they couldn't control whole so-called all under heaven, soul and territory. So they inflict the part of the territories to mainly to their own cousins and relatives, 55 relatives, and equal number, not equal, but less than 50. 30% of people were were the non-relative, the non-blood related people. Actually, they were the meritorious subjects, but then these people were still considered as pseudo family members. So all these the fiefdom was created on the basis of the clan law, the Zhongfa clan law, by seeing as if these people as if they are related to the Zhou clan. So there is no law, and as we understand, it's clan law, which is called ritual. So it's ritual, and everything was based on this ritual, and which is very ambiguous to make sense. It's very difficult to make sense because on the one hand it's kind of a law, on the other hand it's very purely family thing. But anyhow, the whole world was modeled after one big family. That's the bottom line. So tributary system is just like, as she explained, we see these people, these kings, as dukes, and these kings as if they are our family members. And then family members basically, in return of this protection and this benefiction in fiefdom, all these things, in return, we show them the jokeland respect. That's kind of thing. So of course, they are dependent on them. But then joking was almost like, Marx was kind of right in this sense. They were holding both potestas and auctoritas in some sense. If we use Latin terms, they are like, on the one hand, they are like emperor in Roman context, but also they are pope. So when they bestow this investiture to feudal lords, including Korean king later, of course, was basically they were acting like a king, no, pope. It's more like a symbolic thing. It has nothing to do with the actual power relationship. So, for instance, when Korea, Joseon Dynasty in 1932 was created and by overthrowing the previous dynasty, that was perfectly fine. The Korean king created a new dynasty that Korean people don't have to need any approval from the Chinese king, Chinese emperor, or Korean king, and then that was perfectly fine in terms of international relationship. But why still Korean people need investiture from Chinese emperor? Because for the sake of internal domestic legitimation. Because why you guys become suddenly king? Well, then Chinese people don't care about who becomes king, what kind of clan or status of power. But internally, to assuage the people's complaints, whatever, we need this authority, and external authority, which is given by Chinese emperor, which is a universal king in the case. So if we approach this whole relationship from Republican perspective, equality, independence, then there is a lack of independence. That means there is no equality. Then we gonna get into very serious misgiving. Actually, in this case, it's a family model. It's perfectly fine. It's a very different worldview, which has little to do with political power, which has more to do with the symbolic authority. And the investiture was very important, and not in terms of power itself or the right to create a new dynasty, but mainly in terms of how to legitimate the new political authority with regard basically to their own people in their fiefdom.
Thank you for the papers. I thought this two-day exercise was all about demonstrating that the Western international legal system is less humane and that the new international legal system, which might have some Confucian elements, would be more humane, and that there were speakers who demonstrated that Western international law was employed for aggression in the Ryukyus, in Korea, in Annam. But then there were also speakers which quite demonstrated to us that there is an ancient Chinese international law which had some Confucian element in the tributary system and which justified intervention in Annam. And there's an extensive, very detailed account in diplomatic papers showing that Confucianism was being justified to intervene in Annam. It was also being justified to intervene in the Ryukyus. So how can it be any different from the kind of intervention that we see today, international humanitarian intervention in Eastern Europe, in the Middle East? So how do you make us, countries like the Philippines or India or Vietnam, accept this new international legal system with some Confucian element is more humane than the West, when in fact you're mimicking each other, as far as I'm concerned? Thanks.
Okay, thank you. I would say, just like I demonstrated in my presentation, yes, you mean the intervention from a foreign state. I think that Confucianism did not reject intervention completely. Instead, they say that you have to the first thing, the first criteria is you are the superior. But if there is no superior in the world, an equal state can also make intervention. Just like I demonstrated in my PowerPoints, saying that the heaven-appointed officer could intervene. Just like the example demonstrated in Mencius, when the country, when the feudal domain of Yan, there was some unrest there, and another feudal state, Qi, sent troops there to intervene in the affairs of the Yan. And then when Mencius was asked, is it good to intervene in Yan? Mencius said, yes, it's good to intervene in the affairs. But he later said that it was not just for the Qi to annex the Yan or to intervene in the Yan affairs, because the armies of the Qi was not welcomed by the people in the Yan. So I think that it's very clear that the Confucianism would approve some intervention if the intervention is supported by the people of that state. Thank you.
I'm going to take this question from another point, another perspective. I think the reason why we are here joining this conference and presenting these papers or doing research on the Chinese Confucianism and the defects of the current international legal system is not trying to replace the current international legal system just with the Confucianism one. I mean, for one side, I have to say that we are doing the critical research and try to find the defects of the Western international legal system. And we have to recognize that the current one is not a perfect one. And just like what we had showed, it cannot stop the aggression, cannot stop the imperialism. But what you said is also true, that sometimes the Confucianism can also be used as pretext for the Chinese intervention in the ancient China. But I think what we're doing now is, like, when we realize there are some defects of the current international legal system, maybe we should at least to look at some other philosophies. For example, Confucianism is only one kind of approach to see whether we can learn or we can take some elements from them to like help us to reconstruct a better like international legal system for the current international society. Yeah.
I think it's probably time to finish this session. Sorry? Oh, yes. Please last this question. Thank you.
Thank you. I would like to ask a very, practical question. Why did China and Japan restore their relationship so quick after the First Sino-Japanese War? I mean, the war ended in 1895, but the former Japanese premier, the Ito, came to China, meet the Guangxu Emperor in 1898. And he was like a consultant. The Guangxu Emperor consulted him about the reform he was carrying on. But nowadays, it's so difficult to restore China and Japanese the relationship. Do you have any thoughts on why it was the relationship was restored so quick during that time?
Maybe I can say something first, and then Patrick can add more points. I think maybe it's more related to politics or international realities after the First Sino-Japanese War. From the perspective of China, actually, even though during the late Qing dynasty, China experienced like quite several wars, like the first two Opium Wars, the Sino-French War, and also the First Sino-Japanese War. But compared with the other wars, I think the First Sino-Japanese War was the most far-reaching one for China, because this is a war fight between two Asian countries instead of China and the Western powers. Especially Japan was always regarded by China as the inferior country than herself. So China was really like surprised that she would be defeated. So after that, I think China started to re-examine herself like systematically. not only in their perception of international legal order, but also their culture, their own culture, their political system and examination system, something like that. So China realized that she really need to learn something from abroad or open her eyes to the world. And after the First Sino-Japanese War, we can also see that quite a lot of students were sent to Japan to learn from Japan to see why they can strengthen themselves so quickly. So I think compared with other Western countries, Japan for China, has more similarities in culture and in political system, and they both have the empire in their country, something like that. And from the perspective of Japan, maybe we can see that in the late stage of the First Sino-Japanese War, during the peace negotiation, we can see that Japan cannot get whatever they want because of the triple intervention from the West. So you can see the balance of power there, which means Japan had to restrain and find another way to benefit to her most. So maybe establish a better or friendly relationship with China would be the better choice. Maybe Patrick can add more.
Let me add one more point. The invasion was not restricted to military and political terms. There can be cultural invasion and economic invasion. Actually, after the defeat of China in the war, some Western missionaries, such as Timothy Richard, suggested some steps or make some suggestions for the Chinese people. They hope that Chinese people can employ some Western advisors to take control of the railway or the banks, the navies, and the armies. And Japan definitely wanted to do the same thing. So the process of taking over the control of the East Asian was still continuing, but just delivered in a different way. And besides the Western intention, Japan even wanted to do something more because after the war, Japan had actually made a great effort to eliminate the anti-Japanese emotions in China by setting up some societies, Japanese societies, to carry out research on Chinese studies and to give Chinese people some suggestions. And their ultimate aim is to establish some pro-Japanese party in China, just like the pro-Japanese party in Korea. That might be a coup to overthrow the king and then lead to integration. I have a friend in Taiwan who wrote a book on the coup. It suggested that the reforms made in the 100-day reforms made in 1898 was actually led by the pro-Japanese parties, and the final aim was to integrate China with Japan. And Empress Dowager Cixi has been seen as a conservative figure, but this author said that she might have saved China from being integrated into Japan. Since the time is very limited, let me end at this point, and if you are interested, I can show you this book in the coffee break.
Thank you very much. I think it's time to finish this session, and we will have to shorten the break. Maybe we just have a 5-minute break or 10 minutes. 10-minute break, so we'll resume at 5:25 for the last session. Thank you.